Judgment in the appeal, Sea Shepherd UK and Fish Limited.
Lord Tilson will explain the judgment of the court.
On a day in June 2010, there was a confrontation in the Mediterranean when a group of marine environmentalists tried to disrupt the activities of a fishing business. The fishery business, called Fish Limited, operates a fish farm off Malta. On the day of the incident, it was using 2 vessels to transport a catch of bluefin tuna when the vessels allegedly came under attack from the vessel the Steve Irwin. It's alleged that a cage full of fish was rammed and divers from the Steve Irwin tore open the cage, allowing the fish to escape. The fishery has brought this action in trespass in the Commercial Court in London, claiming damages for the damage caused and the loss of the value of the catch. There are 3 defendants: Sea Shepherd Conservation Society, or SSCS, Sea Shepherd UK Limited, and Mr. Paul Watson, who was the master of the Steve Irwin. SSCS and Mr. Watson have no presence in the UK. SSCS was formed by Mr. Watson as a breakaway group from Greenpeace back in the 1970s. It's based in the state of Washington in the USA. It is dedicated to the cause of marine wildlife conservation. It has a number of satellite organisations in other countries. Sea Shepherd UK Limited is a subsidiary of SSCS. It was incorporated in this country and is a registered charity under the Charities Act. In 2010, SSCS launched a campaign under the name Operation Blue Rage because it believed that international regulations governing the fishing of bluefin tuna were being regularly flouted. It announced on its website that the objective of the campaign was to intercept and oppose the illegal operations of bluefin poachers. There are disputed questions of fact about whether the claimant company was involved in illegal fishing on the day of the incident and what exactly happened on that day. But those questions are not the subject of the present decision. The present issue is whether the English defendant has any legal liability for what happened. That was ordered to be tried as a preliminary issue. Mr. Justice Hamlin decided it in favour of the English company. The main issue before him was whether Mr. Watson, as master of the vessel, was acting on behalf of the English company or on behalf of SSCS. The judge found that he was acting purely on behalf of SSCS. But the claimant had an alternative case that the English company knowingly assisted in what was done and was therefore jointly liable with SSCS and Mr. Watson in tort. The claimant relied on a number of matters, including principally the role of the English company in relation to a mail shot soliciting funds for the campaign. Mr. Justice Hamlin reviewed the law and the facts, and he concluded, whether considered individually or collectively, I find the matters relied upon are of minimal importance and played no effective part in the commission of the tort. Accordingly, he dismissed the whole action because the court's jurisdiction over the other 2 defendants depended on the UK company having been properly sued. His judgment was reversed by the Court of Appeal. This court, by a majority of 3-2, has concluded that the Court of Appeal was wrong to reverse the trial judge. All 5 members of the court have written judgments. The majority consists of Lord Newberger, Lord Kerr, and myself. The minority are Lord Mance and Lord Sumption. There is no disagreement as to the law. 2 or more defendants will be jointly liable in tort if they combine to do or secure the doing of acts which constitute a tort. This requires the claimant to show that the secondary party has acted in a way which furthered the commission of the tort by the principal wrongdoer, and that he did so in pursuance of a common design to do or secure the doing of acts which constituted the tort. The difference between the majority and the minority is over the application of that rule to the particular facts. The details of the opposing opinions centering on the fundraising arrangements are set out in the judgments. In summary, the majority consider that the judge was properly entitled to reach the conclusion that the role played by the UK company was of minimal importance and that his conclusion ought not to be disturbed. The minority do not consider that the role of the UK company can properly be described as minimal, and accordingly they are of the view that the Court of Appeal was right. The result is that the appeal is allowed and the decision of Mr. Justice Hamlin is restored.
The court is now adjourned.